Hello viewers, today we will be dealing with the chapter of Biodiversity, Law and Practice. This is a very important topic, and under this we will be covering the important aspects of biodiversity like the international perspectives and the customary law relating to biodiversity and also the law relating to biodiversity in India. First, let us deal with the introduction of this chapter. If we pollute the air, water and soil that keep us alive and well and destroy the biodiversity that allow natural systems to function, no amount of money will save us. The term biodiversity encompasses the variety of life on earth. It is defined as the variability among living organisms and the ecological complexes of which they are part, including diversity within and between species and ecosystems. Biodiversity refers to the number, variety of all life forms, microorganisms, plants and animals, and also the ecological complexes they inhabit. Biodiversity manifests at species, genetic and ecosystem levels. It has direct consumptive value in food, agriculture, medicine, industry. It also has aesthetic and recreational value. From about 70% of the total geographical area surveyed so far, 46,000 plant species and 81,000 animal species representing about 7% of the world's fauna respectively have been described. Out of the total 12 biodiversity hotspots in the world, India has two. One is the Northeast region and the other the Western Ghats. Factors like pollution, overexploitation and degradation coupled with natural causes pose a threat to biodiversity. Long usage of resources gives to a community a customary right over these resources. Indian courts have often upheld a customary right on the basis of proof that the usage has been undertaken long enough and with such invariability that it has been commonly accepted as the prevailing usage in that area. Article 13 of the Constitution of India treats customary law along with other branches of civil law. There is also a provision by which such law can be taken note of judicially under Section 57 of the Indian Evidence Act 1872. However, there are significant constraints and challenges which has to be faced to revive customary law for preserving and protecting the biodiversity in India. The already existing Indian Forest Act 1927, the Forest Conservation Act 1980, the Wildlife Protection Act 1972 and other legislations which pertains to the conservation and management of natural resources do not allow virtually any space to local communities to use their own customary law. Knowledge and appreciation of customary laws relating to natural resources needs to be encouraged. The constitutional 73rd and 74th amendments profess to decentralize controls, point out in the absence of adequate knowledge, appreciation and respect of customary law, conflict situations may arise among the local inhabitants and officials under the acts and the concerned authorities such as the Forest Department. There were certain efforts made by the government towards protection of customary rights and also conserve biodiversity. The National Forest Policy of 1988 brought in the necessity of involving people and respecting customary rights. Perhaps the most progressive in this direction is the 73rd and 74th constitutional amendments, under which panchayats and municipalities respectively have been given greater powers for administration and management of biodiversity too. Now, the United Nations Convention on Biodiversity 1992 and its significance. Biodiversity is defined by the United Nations Convention on Biological Diversity as the variability among living organisms from all sources, including terrestrial, marine and other aquatic ecosystems and the ecological complexes of which they are part. This includes diversity within species, between species and of ecosystems. The Convention on Biological Biodiversity was concluded in June 1992 and has been signed by over 180 countries. The Convention on Biodiversity has been instrumental in putting the concerns for conservation of biodiversity on the international agenda. The Convention aims at establishing a controlling system in protected areas, developing legislation, regulatory provisions for protection of threatened species and populations, regulating the adverse environmental impacts resulting from biotechnology, including risks associated with the use and release of living modified organisms, developing guidelines for selection, establishment and management of protected areas, developing legal basis for innovations and practices of indigenous and local communities and ensuring their wider application, protecting ecosystems, natural habitats and regulating biological resources within or outside protected areas to ensure both conservation and sustainable use. While Article 8 of the Convention requires the need to develop regulatory provisions for the protection of threatened species, Article 9 relating to ex situ conservation mandates that the contracting party should adopt measures to rehabilitate species into their natural habitats. An integral approach to biodiversity is also asserted by the Convention, as it requires each contracting party to integrate consideration of the conservation and sustainable use of biological resources into national decision making. The 20th century, particularly the 1980s and 1990s, has witnessed the increasing use of legal and judicial process to protect and preserve the environment and its natural resources by Indians. One such process is the conservation of biodiversity. The issues relating to ecology and quality of habitat have been repeatedly addressed through public interest litigations, bills, filed under Article 32 and 226 of the Constitution of India in the Supreme Court and different High Courts. The Constitution of India through Articles 48A and 51A Clause G of the Constitution of India will have the direct bearing in preserving and protecting the biodiversity. In a series of cases, the Supreme Court of India called for the legislation of the activities relating to biological diversity and advocated the concept of sustainable development. Biological Diversity Agenda 21 of United Nations Conference on Environment and Development 1992 has a significant role. Agenda 21 is a blueprint for action in all areas relating to the sustainable development of the planet in the 21st century. The agenda calls for changes in the economic development activities of all human beings, the changes that are based on a new understanding of the impact of human behavior on the environment. The Convention on Biological Diversity. The objective of the Convention on the Conservation of Biological Diversity, the sustainable use of its components and the fair and equitable sharing of the benefits arising from commercial and other utilization of genetic resources. The Convention on International Trade in Endangered Species of Wild Fauna and Flora aims to ensure that international trade in specimens of wild animals and plants does not threaten their survival. Through its 3 appendices, the Convention accords varying degrees of protection to more than 30,000 plant and animal species. The Convention on the Conservation of Migratory Species of Wild Animals. Parties to this convention work together to conserve migratory species and their habitats by providing strict protection for the most endangered migratory species by concluding regional multilateral agreements for the conservation and management of specific species or categories of species, and by undertaking cooperative research and conservation activities. The International Treaty on Plant Genetic Resources for Food and Agriculture. The objectives of the treaty are the conservation and sustainable use of plant genetic resources for food and agriculture, and the fair and equitable sharing of the benefits arising out of their use. In harmony with the Convention on Biological Diversity for Sustainable Agriculture and Food Security. The treaty also includes provisions on farmers' rights. The Convention on Wetlands, popularly known as the Ramsar Convention. The Ramsar Convention provides the framework for national action and international cooperation for the conservation and wise use of wetlands and their resources. The World Heritage Convention. The primary mission of the World Heritage Convention is to identify and conserve the world's cultural and natural heritage by drawing up a list of sites whose outstanding values should be preserved for all humanity and to ensure their protection through a closer cooperation among nations. The International Plant Protection Convention aims to protect world plant resources, including cultivated and wild plants, by preventing the introduction and spread of plant pests and promoting the appropriate measures for their control. The convention provides the mechanisms to develop the international standards for phytosanitary measures and to help countries to implement them and the other obligations under the IPPC by facilitating the national capacity development, national reporting and dispute settlement. Now, the most interesting topic that has emerged, biodiversity and biotechnology. Biotechnology means application that uses biological systems, living organisms or derivatives thereof to make or modify products or processes for specific use. In a broad sense, the definition covers many of the tools and techniques which have been commonly used in agriculture and food production, processing and utilization, and in a narrow sense, however, it encompasses DNA techniques, molecular biology and reproductive technological applications, dealing primarily with gene splicing and recombination and genomics. The term is normally used to cover technologies that overcome natural physiological reproductive or recombination barriers and that are not techniques used in traditional breeding and selection. This definition is based on the Cartagena Protocol on Biosafety, which was adopted under the umbrella of the Convention on Biological Diversity. There is a widespread misconception that biotechnology development will automatically lead to biodiversity conservation. The main problem with viewing biotechnology as a miracle solution to the biodiversity crisis is related to the fact that biotechnologies are, in essence, technologies for the breeding of uniformity in plants and animals. If misused, biotechnology may prove to be dangerous. Now let's deal with the salient features of Biodiversity Act 2002. Biological Diversity Act 2002 is indeed a pioneering piece of legislation from the Indian context in preserving and protecting the biological diversity. This aims to promote conservation, sustainable use and equitable sharing of benefits of India's biodiversity resources. This act is an important step in the attempt to assert the sovereign rights of the people of India over their genetic and biological diversity resources. This act further envisages the creation of authorities at national, state and local levels. They are supposed to advise the central government on any matter concerning conservation of biodiversity, sustainable use of its components and fair and equitable sharing of benefits arising out of the use of biological resource and knowledge. Some of the major functions of these authorities are to grant approval under sections 3, 4 and 6 of Biodiversity Act 2002, to notify areas of biodiversity importance as biodiversity heritage sites under this act and perform other functions as may be necessary to carry out the provisions of the act. To take measures to protect biodiversity of the country as well as to oppose the grant of intellectual property rights to any country outside or any biological resources obtained from India. The offences under the Biological Diversity Act are cognizable and non-bailable. Under section 58, a non-citizen and an Indian who is an individual or a body corporate having non-Indian participation if undertakes biodiversity related activities without prior approval of the National Biodiversity Authority shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakh rupees or both. Any citizen of India excluding Vaids and Hakims who are practicing indigenous medicines who obtain any biological resource for commercial utilization or biosurvey without giving prior intimation to the State Biodiversity Board in violation of section 7 shall be punished with a fine which may extend to 1 lakh rupees and in case of second or a subsequent offence with fine which may extend to 2 lakh rupees and in case of continuous contravention with additional fine which may extend to 2 lakh rupees every day during which the fault continues. The judicial activism part. The judiciary in India has played a very important role in the environmental protection and has applied the principles of sustainable development while deciding the cases. The following cases are noteworthy. Rural Litigation and Entitlement Kendra, Dehradun versus State of UP, AIR 1985 SC 652. This was the first case of its kind in the country involving issues relating to environment and ecological balance, which brought into sharp focus the conflict between development and conservation, and the court emphasized the need for reconciling the two in the larger interest of the country. In this case, mining which denuded the Mussoorie Hills of trees and forest cover and accelerated soil erosion, resulting in landslides and blockage of underground water, which fed many rivers and springs in the river valley, was the issue. The court appointed an expert committee to advise the bench on the technical issues, and on the basis of the report of the committee, the court ordered the closure of number of limestone quarries. The Rural Litigation and Entitlement Kendra versus State of UP, AIR 1991 SC 2216, the second important case. The Supreme Court allowed a mine to operate until the expiry of lease as exceptional case on undertaking by the lessee that land taken on lease would be subjected to afforestation by him. Consequently, when it was brought to the notice of the court that he had made a breach of the undertaking and mining was done in most unscientific and uncontrolled manner, causing damage to the area and environment, the court directed the lessee to pay rupees 3 lakhs to the fund of the monitoring committee, which had been constituted earlier by the court to supervise the afforestation program to be undertaken by the lessee. It is submitted that the order of the court is based on the principle of polluter pays, which is one of the essential principles of sustainable development. Next important case is MC Mehta versus Union of India 1996 8 SCC 462. In this case, public interest litigation, a bill was filed seeking direction from the court to stop the mining activities in the vicinity of touring resorts of Batkal Lake and Suraj Kund in the state of Haryana. The Haryana Pollution Control Board recommended that mining activities within a radius of 5 kilometers from the tourist resorts should be stopped. Similar recommendations were also made by the National Environmental Engineering Research Institute, NEERI, Nagpur. Having regard to the opinion of two expert bodies, the court held that mining activities in the vicinity of tourist resorts were bound to cause severe impact on the local ecology, and therefore mining activity should be stopped within 3 kilometers of such tourist resorts. The Monsanto Myco case, writ petition number 41532 by 2012 GM-RES Bill. In the High Court of Karnataka at Bangalore Environment Support Group versus Respondent, National Biodiversity Authority, represented by its chairman and others. In this case, the National Biodiversity Board and Karnataka Biodiversity Board filed a criminal complaint of biopiracy before the High Court of Karnataka. However, the petition filed for criminal proceedings was stayed for an unprecedented period of 6 months in January 2013. But in a significant ruling, the High Court of Karnataka dismissed on 11th October 2013 petitions that sought quashing of criminal prosecution against Monsanto Myco, who had been accused by the National Biodiversity Authority and Karnataka State Biodiversity Board of committing serious criminal acts of biopiracy. The next case is of National Green Tribunal orders status quo on activities of DRDO, BARC, ISRO and IISCs in Challakere, Chitradurga, Karnataka. In an unprecedented decision of an issue, the Honorable National Green Tribunal, South Zone, Chennai, ordered status quo on all project activities proposed in the Amrit Mahal Kaval grassland ecosystems of Challakere Taluk, Chitradurga, Karnataka with immediate effect. The directions were issued on the interim prayers filed in applications by the undersigned, which complained that Defence Research Development Organisation, Indian Institute of Science, Indian Space Research Organizations, Baba Atomic Research Center, Karnataka Small Scale Industries Development Corporation, Karnataka Housing Board, Sagitar Private Limited have commenced project activities in these ecologically sensitive areas in comprehensive violations of laws protecting the environment, wildlife, forests, people's rights. This order was issued as it was contended that Kaval grasslands, a rich source of biodiversity, has been used for the establishment of a massive weaponized drone testing and manufacturing facility by DRDO, Defence Research and Development Organization, a major nuclear fuel enrichment plant by Baba Atomic Research Center, a synchrotron by Indian Institute of Science, a space application center by ISRO, and also a massive solar power plant by an unknown company called Sagitar. In addition, there are various other associated industrial and infrastructure developments proposed, both Indian and foreign, especially in the defense manufacturing sector, which has recently been opened up for foreign direct investment. As for the concluding part, biodiversity starts in the distant past and it points towards the future. Though the Biodiversity Act has been made effective, but there are certain loopholes which exist in the Act. These are inadequate access to local communities, non-inclusion of genetic resources, and limited access towards benefit sharing. In order to take care of these loopholes, a biodiversity management committee can be formed. Viewers, hope you enjoyed this session. Next session will be dealing with hazardous waste management, law and practice. Thank you.